what are normative systems? So the aim of computational logic is to identify and to provide the techniques, methods, and formalism to formalize, to provide a logical representation, a formal representation of a set of norms, of a normative system. And then, after we have that, we have to identify what are the normative positions, obligations, prohibitions, and permissions in force in the system, and also to consider whether we comply or we violate some of those conditions or not. But then essentially what we have to do, we have to understand what is a normative system. So as I've already mentioned, for us, a normative system will be just a set of clauses or just a set of norms. And then those norms will be represented as a set of if-then rules. So an if-then rules will have this format here. So this will be the logical representation, where we have a set of conditions, A1 to AN, or also the premises of the rule or the if part of the rules. So the condition under which we are going to apply the rule or the norm. And then we are going to have C, the conclusion, or what is the effect of the norm. And then, well, there's the arrow, it's just the symbol to represent that this is just the if-then part. So the if part, it's the A1 to AN, the condition of applicability. The then part is the effect or conclusion of the rule. Now, then when you look at some examples, for example, if you look in a contract or if you look in an act, you will see that typically there are, at least we can identify two major components. So typically there is one section about the terms and definitions, where essentially the terms, the elements used to define the document or the legal context are defined. And essentially we will have conditions and norms describing what are and how to understand the terms in that particular document. So for example, if we consider some definitions, we might consider what is the definition of an adult. An adult can be defined as a person whose age is at least 18 years old. And then we can consider other conditions. So what we do, we will have a part which is about defining the terms. We can speak of definitional clauses or constitutive rules, but then we will also have other norms, and we will have what we can call prescriptives or normative clauses. And essentially, the key aspect and the intuition of the prescriptive clauses is that, well, we will have some condition of applicability, the if part, and we will have a normative effect. So the normative effect, then it's that, well, something is then an obligation. So an obligation is in force if the condition of applicability hold, or something is permitted, and that it will be the effect if the condition of applicability hold, or something is forbidden, and again, under what condition it's that's something forbidden. And also, well, we can use the prescriptive clauses to specify what to do and to identify whether we have some violations and what are the possible compensations for those violations. Now, the other aspect we have to consider, and then, well, I've just mentioned a couple of times, it's then typically when we look at, in particular, large normative systems, then those documents will define baseline conditions, and then they will provide exceptions. So in general, we can say that the norms are defeasible. And here by defeasible, we mean that the norms admit exceptions, and then what we want to do is to identify what are the mechanisms to reason and to represent in a natural way the exceptions. Okay, then what we spoke about the normative effects, so essentially the conclusion of the prescriptive clauses, and then essentially the effects that we are going to consider are obligations, prohibitions, and permissions. And here we can take the definitions provided in the legal element standard, and essentially they just define an obligation, prohibition, and permissions, where an obligation is a situation, an act, or a course of actions to which a subject is bound, and we have a violation if the situation, act, or course of act it's not achieved or performed. A prohibition is very similar, so there is a subject, but this time the violation, if it's the water it's forbidden, it's done or it's achieved. So essentially, the prohibition, you have to do something, and if you don't, you have a violation. In a prohibition, you have to refrain from doing something, and if you do, you have a violation. And finally, the permission is said that something is permitted if it's not forbidden, or we don't have the obligation to the contrary. And then here, what we have to be more precise, if the prohibition, we don't have the prohibition for it, it's not in force, or the obligation to the contrary, it's not in force. And then essentially, if we just say that the prohibition is not in force, then we can capture with this definition both the intuition for the concept of weak permission. Well, the system is silent in the particular situation whether something is forbidden or not, and the case where the prohibition is derogated, we have an explicit exceptions to the obligation or prohibition. Now, important aspect, obligations and prohibitions can be violated, and the system can contemplate conditions to compensate for violations. And this is just about the terminology. Typically, we will use this abbreviation as the symbol for obligation, this for permission, and this symbol for permission. Now, important point, permissions cannot be violated. You can only violate an obligation or you can violate a prohibition, but permissions cannot be violated. Now, what you can say, well, you can ask, what about rights? So a right is a particular type of permission that implies the existence of an obligation, typically of a third party. So to understand the difference between permissions and right, well, consider, for example, parking, maybe parking in your university or in the campus of your institute. So you might have a permission to park if you are a staff. You might be permitted to park there, but also you might have the right to park. So what is the difference between those two situations? What is the difference between, well, you buy, let's say, a parking permit, and when you buy, let's say, a guaranteed parking permit? In the first case, you have just a normal permission. In the second case, you have a right. So if you have just the parking permit, then essentially, well, if all available spots are taken, well, bad luck, and essentially say, well, I'm not able to fulfill the permission. I was permitted to park, but it's not possible today, so bad luck and nothing to do. However, if you have the right, so essentially if you buy a particular kind of permit where essentially they guaranteed the parking, so you have the right to park, then the university has to guarantee that, or the institution has to guarantee that there are enough parking spaces so that you can park there, and otherwise they are at fault. So here, if you have the guarantees, you are permitted to park, but then there is an additional obligation on another party to ensure that there are enough parking spots available. But then essentially, if you have the violation, you do not violate the permissions part, but there is the violation on the additional obligations related to the permission corresponding to the right. Okay, now let us consider this example here. And well, unfortunately, this is would have been, if we were, let's say, face-to-face, it would have been interactive, but unfortunately, we cannot do interactive today. Now, let us consider this fragment here. Let's say that it's just a fragment for the provision of services or goods. And then essentially, we will have those clauses here. So the question is, well, what about conditions 3.1? Is the condition a prescriptions or it's just a definition? Well, I would say in this case, then it should be reasonably simple. It should be a clear case, a clear-cut case. And then here, essentially, the condition specify or defines that a customer is a premium customer, provided that one condition is satisfied. So provided that, well, there is a expenditure of over $10,000 in goods. And then essentially we have the condition. Now, let us consider 3.2. Is this condition here a prescription or it's a definition? Now, if you are in doubt, then essentially you can use the typical lawyer answers as well. It depends. So that is the typical way a lawyer will say, will answer when you ask them a question. And then depending on the type of answer, you can also determine what kind of legal professional they are. So if they go for it depends, it's a lawyer. If they give you a definite answer, so they give a yes or no, then typically there will be either judges or law professors. And then, well, if they are judges, they will give you also a lecture of 30 minutes why it's so. And then if they are law professors, they will say, well, they will give 2-hour lectures where they will consider all possible theories why it's yes and all possible theories why it's no. And finally, why you have to choose one of solutions or not, and why some of their colleagues will go for the opposite solution. Well, okay, that it will be the bad joke. Now, in this situation, yes, we could say it's not a completely clear cut, but for me, my intuition is that it's a definition. It just provides us a recipe on how to compute a special order. So the price for a special order, should be computed just based on the normal price, and then you have a 5%. Now, what is interesting in this condition here is that also, even in this recipe, we have an exception, because when we consider the second part, the second sentence in this provision here, premium customers are exempt from special order surcharge. So it means that normally we have to use the standard special order condition. However, if we have a special order from a premium customer, then we have to ignore the surcharge, and then we can go back with the original condition. Okay, now, what about the provision 5.2? Well, probably here we can go back to the base condition, and here we have an important keyword. So we have shall. And then probably here what we can do, we can take shall, and then this gives us that this condition here is for an obligation. And then we will have, there is a condition, so there is a purchase, there is a receipt for a purchase, and then after you have the receipt, the supplier has the obligation to provide the service within 1 day. So we receive the purchase order, and then you have the obligation to do something else. Now, what about 5.3? Well, 5.3 is quite interesting because, first of all, we have no idea whatsoever in 4.1 and 4.2, just looking at what is written here. However, what we can do is say, well, okay, there were some conditions and those conditions were not met. So very likely, these speak about some possible compensations. So essentially, what you have to do if there are a violation of the conditions specified in 4.1 or 4.2. And then, as a response, then essentially we have an entitlement, which is a permission. So the purchaser, it's permitted to charge something. And then what we have, if the purchaser, let's say, exercise the permission, then there will be the obligation on the other party, on the supplier, to pay a particular price. Now, if we look at these 10 lines, then essentially what we do, we have examples of definition. So we have to use constitutive rules or definitional clauses. Also, we have examples of exceptions, in particular, an exception for a definition. And then we have an example of a prohibition or just a prescriptive clause. And finally, we have an example where there is an obligation that possibly imply, a permission possibly implies an obligation. And then, very likely, that prohibition is a compensatory clause. Now, if in 10 lines we can have all those aspects, then consider when you have over 100 pages. You will have many of them. So it means that if we want to be able to represent in the proper way legal documents and the content, and we won't represent them in a formal way, we need to be able to represent obligation, definitions. So we need to model definitions. We need to model conditions for obligations. We need to model conditions for prohibitions. We need to model conditions for permissions, and also to represent conditions specifying possible compensatory measures. And also, we have to have the ways to model exceptions. And then this should be done on a large scale. And one of the problems, as we partially can see here, then here we might not have immediate access to the content of 4.1 and 4.2, but we want to be able to model in a way that we have to just look at particular sentences, as particular clauses, and based on what is specified in those clauses, provide a formal representation for those clauses without looking at the other conditions. And then to achieve this vision, then we can move to the next part, in particular on how to model exceptions and how to represent in an efficient way the defeasibility of the norms. So, well, what is our slogan for defeasibility? Now, what we want to do is we want to be able and we want to be to reason and to obtain meaningful, good conclusions based on the information which is provided. So a reasonable result with minimum effort. We want to derive what is in force with just what is provided in a particular case, just the conditions that are given in a particular case. Okay, now let us consider this example here, and then, well, this is, well, a scenario, well, if you work in universities and you did a PhD, you might be familiar with. And then let us consider what are the possible rules for the PhD student. Well, we want PhD student to work hard to achieve their degree. So with the first rules, then it's, well, if you are doing a PhD and you're a PhD student, then you have to spend most of the time at the university working hard on your work, on your thesis. Well, however, well, as supervisors, we are good guys, so, well, we allows students to stay at home, not to come to the university on weekends. Also, we allow them to stay at home on public holidays. And well, consider we are really good guys. They don't have to come to office if they're sick. Okay, so it seems we are good. However, well, what about it's a weekend and there is a deadline for a very important conference? Well, here a very important conference very often it's defined as a conference that where you as supervisor, you can drop an email to the chair of the conferences. Look, I know the deadline is today, but look, I wasn't able to do anything, but I have my student. I can ask the student to write the paper over the weekend. So if you give me an extension till the weekend, after the weekend, then yeah, the paper is done. So if that is your situation, so if you have a weekend and a very important conference deadline, then essentially, well, the student should stay should go to the university working for you. So while you can stay home, go to the beach, and then you have the paper on Monday. Well, however, what about, yes, there is the VSC conference deadline. However, it happened to be the birthday of the partner of the student. Well, in that situation, well, the student will stay home and not come to the university. Well, to be honest, I've never had this particular situation. However, a few years ago, I have a similar situation. It was not the birthday of the partner, but it happened to be the weekend where there were the soccer World Cup final. And the outcome was we didn't submit the paper. Yeah, too bad. Now, so those are just the rules, and then essentially is can we model them? Can we model this situation in classical propositional logic? And the answer simply is yes, you can definitely do it. However, what it's required to model this situation in classical propositional logic, it's to have factual omniscience. So what you have to do is that for every condition, for every term, you have to know whether the term, the condition, or its negation alter or not. So what you have to know whether somebody is a PhD student or not. Then you have to know whether it's a weekend or not. You have to know whether it's the deadline of the very important conference. You have to know whether it's the birthday of the partner of the student or not. You have to know whether the student is sick or not. You have to know whether it's a public holiday or not. So essentially, you have to have knowledge of all possible aspects. For every particular condition, for every particular term, you have to know whether the terms are in negation, alt or not. And then this, it's very often unfeasible and it's not required in legal reasoning, because in legal reasoning, when you examine a case, you have to make a deliberation just based on the information which is provided in the case. Plus, in some cases, you might have some assumptions which are guaranteed by the law system, by the legal system, but those are specifically contemplated by the legal system, and then that is the only thing you can assume. For everything else, you have just to base on the information which is provided in the case. And then essentially, it's unrealistic that you know that you have the complete picture of every possible combination of the parameters. You will know only some of them, and you want to reach a plausible, meaningful, legally acceptable conclusions just based on the information provided. Okay, now, just to show that, yeah, it's not on what we just consider for the contrived case of the PhD students, so yeah, it will be just some rare situation for us academics. But let us consider the situation here. So let us consider section 2.1 of the Telecommunications Consumer Protection Code. And then here, the idea is that, well, these definitions just provides the definition of what is a complaint. so which is an expression of dissatisfactions either for a product or a process or something else. And so when we do in the first paragraph, we have that, well, that it will be the general definition of complaint. Then when we go on, when we consider the second paragraph, then it specifies that, well, an initial call to request a service and or information or to request some support, it's not necessarily a complaint. Also, an initial call to report a fault or self-service difficulty is not a complaint. However, if the customer advises that they wanted this initial call, which otherwise would not be a complaint, to be treated as complaint, then the call will be a complaint, even if normally it would not be a complaint. And then, well, what we have, we can also, there is another part, but it's this final part, it's not relevant for what we want to do. It's not relevant for the point here. Now, that was an example where we have a constitutive, a defeasible constitutive rule. So a constitutive rules where we have a baseline condition, we have some possible exceptions. So an expression of dissatisfaction, baseline condition, is a complaint. An initial call, it's not, and that it will be the first exception. It's an exception to the baseline condition. Then we have an exception to the exception. So if there is, if the caller, the customer, specify or make clear that it's a complaint, then it is a complaint, which is an exception to the exceptions, and so on. And then also we can have the same situation for prescriptive clauses. So consider section 29 of the National Consumer Credit Protection Act, where we have the baseline condition. It's the prohibition to engage in a credit activity. So a person must not engage in a credit activity. And then we have if the person does not hold a license authorizing the person to engage in a credit activity. And also here we can see that, well, if the person holds, that will be an exception. Or also we can see now, we can ignore what is section 2. Section 2 in this act, it's just a person commits an offense under sections 1 if engaged in a credit activity without having a license, which is, well, essentially what it's essentially the same thing specified in section 1. But then we can go on with section 3, and then essentially it specifies what is a defense. So under what condition it's permitted to engage in a credit activity, and then essentially they start to list some particular condition. Now, in this situation, if I remember right, the act has just, well, one line for the baseline condition, 2 lines, 1 line or 2 lines for, well, specifying section 2, which is the offense. Also in section 2, you will have a specifications of what are the penalties. So section 2 specifies that it's what is the civil penalty and what is the criminal penalty. And then in section 3, which goes on for 5-6 pages, you have a list of exceptions. Then after, you will have in section 4, you will have for another 3-4 pages exceptions to the exceptions. And we are lucky in these situations because there are only 3 levels: baseline, exceptions, and exception to exceptions. And in general, I would say this is a reasonably, it's a very common structure: baseline, exceptions, exception to exceptions. There are some rare cases where there is a 4th level, exception to the exception to the exceptions. In a very few rare cases, and well, we recently discovered one of them, there are 5 levels. So baseline, exception to the baseline, exception to the exceptions, exception to the exception to the exceptions, and exception to the exceptions or the exception to the exceptions. And then it starts to be complicated to understand what they want to do. So I would say 3 levels, it's good and it's reasonably understandable what's going on. 4 level, it's start to be very hard. If you have 5 levels, the drafter and the lawyers who wrote that piece of legislation did a very good job, in the sense that only them were able to understand what it's written and nobody else. Well, we might argue whether that is a good job or not. Now, so let's see how to go on and what are the next components and how to model the different elements. Now, already we have seen that we want to use some deontic operators, and here we just introduce the operators for obligations and permissions. And we will consider some additional aspects here. Now, here what we can do, and as I told you before, the idea of the deontic expressions is that they modify the truth or they qualify sentences which would be otherwise true or false. In particular, here they take an expression which will be true or false. Let us go. Here we have just an example from the sample of the possible contract for a service. So here we have the condition for the special orders. They say the special order price is X, and then this is computed at the special order price for an item X. It's computed considering the price for the item X, and then you add 5%. And then essentially here you compare 2 values, and then you see whether that comparison of the 2 values it's true or false, it's the same or not. So you have just a statement, and then also you can have some other statements, such as make goods available within 1 day, which is a condition which is true or false. But then when that expression appears in the scope or in the context of an obligation, then now of the deontic operator for obligation, here we see that we will use additional information. Those are called directed deontic operator, where we can specify the subject or a party in the to whom the obligations refers to, and then essentially it transforms that statement which is true or false into an obligation. So in this sense, when we read this particular expression here, we will have that now we have the obligation, and in particular the supplier has the obligations to make goods available within 1 day. And then similarly, we have a charge supply, which is something which will be true or false, whether a person, the purchaser, charges the supplier or not. But then when we prefix with the deontic operator plus the specification of the subject, then we might get a situation where we get that, well, now we have a permission. The permissions refer to a purchaser, and then the content of the permission, it's the true or false expression, it's to charge to the supplier. So we can combine, and we get that the purchaser, it's permitted to charge the supplier, and then we can go on. Now, typically, well, the deontic logic and the deontic relationship, so how we manipulate, how we compute what is obligatory and permitted, was based on standard deontic logic. So this is the logic that defines what are the logical properties, what are the logical computations we can perform, and essentially there are some basic principles. So in this line here, we just consider some of the principles we have already seen, and essentially the connections and the relationships, the logical relationships between obligations and permission. So we have that if alpha is obligatory, then this is equivalent, it means it's the same as. It's not the case, negation, that the opposite of the content, not A, it's permitted. So if it's obligatory A, it's not the case that not A, it's permitted. So if you have to do A, it's not the case that you can refrain from doing A. Similarly, we can see on the other side, on the other situation, if you are permitted to do alpha, then this is equivalent that it is not the case that it is obligatory, not alpha. So if you are permitted to do something, then there is no obligation to do the opposite. So otherwise, you would not be permitted because you have to do the opposite, and so essentially you do not have the freedom of doing what you want to do instead of the opposite. Then in standard deontic logic also you have this principle here. So if you have the obligation of an if-then, so if you have the obligation that if alpha then beta, then you have, if there is the obligation of alpha, you have the obligation of beta. So essentially we have that the obligation distributes over implication of if then. Finally, the last principle we have, and then it's what we discussed before, was that if you have the obligation of alpha, then alpha should be permitted as well. Also, the way to look at this is also to consider the alternative, and then this means, well, if you have the obligation of alpha, it's not the case that alpha is forbidden. Remember, obligatory not corresponded to the prohibition. So this means that if you have an obligation, if you want to model, if you want to be able to reason in a proper way with deontic operators, it should not be the case that something is obligatory and forbidden at the same time, otherwise you will get an inconsistency. And then this is the meaning of this expression here. However, when we consider the deontic logic, and in particular standard deontic logic, then we have a problem because standard deontic logic has problems with violations. So it's not able to reason properly when we have conditions specify that something should be done in response to a violation. So let us consider this particular situation and what will be well for rules when you give some lectures on AI and law. So well, in particular, what about possible rules for giving tutorial at URIX? And then essentially I have those 3 rules. So it is forbidden to tell lies in tutorials. And then if there is a lie, if the presenter give a lie, tell a lie in the tutorial, then the presenter has the obligation to explain why there was a lie. And the third one, it ought to be the case that, well, if the presenter does not tell a lie, so then the presenter does not explain why. And finally, suppose that in this particular presentation, there will be a lie. And also, yeah, it's up to you to spot when there is a lie. So how can we model this situation? How can we model those 3 norms plus a factual statement in standard deontic logic? Well, what we can do is just to model with those 4 formulas. So we have obligations not to lie, that is that there is a correspondence between the first statement and this particular expression here. Then if there is a lie, then there is the obligation to explain. And then here what we can see in the third statement, well, the third statement has the obligation, and then it makes obligatory an if-then inside. So the other alternative is to consider as a possible or, where it will be logically equivalent, and then essentially we will have obligatory. If there is no lie, then no explanation, and finally there is a lie. Now, remember, those are the principles we're going to use. So if we have an obligation, and the obligation refers to an if-then, and there is the obligation of the antecedent of the implication, we will also have the obligation of the consequent. So when we consider this obligation here, obligation not to lie, and this complex obligation here, we will get that we have obligation to not to explain. But when we consider this norm here plus the factual statement that there is a line, then we will get that at the same time, when we combine everything, we will have obligation to explain from this one and this one, and obligations not to explain or prohibition to explain from this condition, from this norm here and this norm here. So what should I do? Because at this time, if there is a lie in my presentation, I have the obligation to explain, and at the same time, I have the prohibition to explain. So no matter what I do, I cannot comply, because if I do explain, I comply with this obligation, but I fail to comply with the prohibition or the obligation to explain. If I don't explain, I comply with the prohibition of explaining, but then I violate the obligation to explain. So no matter what I'm going to do, I'm in trouble because I cannot be compliant. So what's the solution? And then, well, here's to show how much of a, let's say, of a geek or a nerd I am. And well, so essentially my solution is to use a solution that, well, similar to the Kobayashi-Maru solution. So when James T. Kirk was a young cadet in the Space Academy, he was the only one who was able to successfully pass the Kobayashi-Maru simulation. And that was a simulation where no matter what you do, it was a failure, and then it was the spaceship was blown away. But it was the only one which was able to pass. So what was the solution? It changed the parameter of the simulation. So what we are going to do here is exactly the same. So instead of using standard deontic logic, well, what about if we change the logic and then we try to address what is the problem with standard deontic logic? So the problem we have is when we have, and we have already seen this particular structure, when we have some chains of norms where the condition of applicability of a norm related to the possible violation of another norm, of the obligation of another norm. So here we have, if A, then it's obligatory B. If we have not B, which will be the opposite of the content. So essentially, this, if we have both of them, we have obligation of B, but not B, so we have a violation. And then essentially, we will have obligation of C. Then here we will have the same. So essentially, we should be able to represent possible concatenations of obligation in force. Those obligations can be violated, and then the violations will trigger some additional conditions, which in some cases will constitute a compensation, or they will a reparation, a reparatory condition for the violation, and then we can combine multiple of them. So what about if a situations where we have A, not B, but D? So in the situation where we'll have to have obligation of C, so if we do C, we comply here. If we don't do C, if we do not C, we still have a one way possible to compensate and to do D. Then essentially what we have to do, we have to devise a logic that allows us to work with violations and be able to represent them. Now, what are the key elements for this logic? Well, here we will concentrate just on the prescriptive clauses, and then what we have, a prescriptive clauses is an if-then rule, where essentially the then part will be, the content of the then part will be within in the scope of a deontic operator, in particular of an obligation or a prohibition, if we want to consider violations. Now, then the first thing we have to consider is that it's not possible to have a violation without an obligation the violations violates. So if you want to have a violations, we must have that something should be done and we haven't done. So we need to have an obligation in force. Otherwise, we cannot speak of a violation of an obligation. Similarly, when consider a compensation, it's not possible to have a compensation for a violations without a violation, the compensation compensates. So we must have the First, that there is a violation, and then the violations trigger the compensation, which is related to the violation itself. Now, what about the intuition? What is a reparation? Well, the reparation can be an obligation, it can be a permissions, and so on. But if it is an obligation or prohibition, then this can be violated. So what we did, we have to be able to combine some of them, and remember, permissions cannot be violated, but then when we have a violations or prohibition and those can be violated, what we can do, we cannot consider the single prescriptive clauses in isolations, but we have to consider whether there are possible compensatory measures to be combined together. And also, when we have then, we have to, it is possible to have some, not just one obligation and the compensatory measures, but also since the compensatory measure can be an obligation or prohibition, so it can be violated, so we can have a possible change of them. Finally, and then essentially when we combine those two conditions is, well, when we combine prescriptions and then we have possible compensatory measures, what we can do, we can obtain new prescriptive clauses from already existing prescriptive clauses. And then essentially what we do, we want to take the most expressive, the condition that subsumes in the meaning all of the others. And then this is what we are going to consider in the next part. So now we have all the elements to move to the next part of the presentation of the tutorial, where we concentrate on just specifying the proper logic. So we specify the feasible deontic logic and the mechanism for the logic.